Libel, privacy, accuracy and balance in a few minutes. Libel is untruthful publication to a third party that seriously harms reputation, can identify by innuendo, and cross-media jigsaw connections. The burden of proof is on the defendant. The UK Supreme Court in the Lachaud case in 2019 means claimants have to prove serious harm by reference to the actual facts about a publication's impact, not just the meaning of the words. Harm to a reputation of a body that trades for profit is not serious harm unless it has caused or is likely to cause that body serious financial loss. Defenses include honest opinion, truth, a reasonable belief that the publication, either fact or opinion, was a matter of public interest with an allowance for editorial judgment, privilege in fair and accurate reports of courts, parliament, public meetings, press conferences, and peer-reviewed scientific or academic conferences and journals. Prior restraint in libel is not usually available if the media defendants intend to defend their case. Media privacy and confidentiality stem from Article 8 of the Human Rights Act, protects private information, either truthful or not truthful, such as health, relationships, sexuality, home correspondence, and family life. Where there's a reasonable expectation of privacy, intrusion and publication has to be justified by public interest. Breach of privacy can be by media conduct as well as by media publication. Prior restraint is usually available because privacy is like a cube of ice. It's gone once melted. Now English courts have to hold a hearing and hear legal argument against prior restraint before issuing injunctions. Even where parties remain anonymous, the legal system has to keep and make available a record of the decision. The media must have notice of prior restraint applications. Inaccurate publication that neither harms reputation nor breaches privacy can still lead to fines, prominent corrections and apologies by Ofcom regulation of broadcasters and independent press regulation of print media. No public interest defense is available. Broadcasters have a legal duty to be impartial and avoid giving undue prominence to views and opinions. The press can be partial, but the editor's code expects a distinguishing between comment, conjecture, and fact. The right to be forgotten, asserted in the EU's Court of Justice ruling in 2014, applies to the delisting of information by data processing search engines such as Google, not the archive of journalistic publications. However, there's case law developing in the European Court of Human Rights in Strasbourg that proposes extending delisting to tags in online news articles and even removing the identity of people in online stories. UK data protection legislation, and regulated by the Information Commissioner's Office, imposes public interest duties on media processing of private information and its publication.